Welcome to another episode, everyone. Oh, Big U may be coming home. He just got a big win in court against the feds. And the word is out on the street. And these internet goofies are running scared to death because they got the word that Big U may be on his way home. And a lot of people have had a lot to say about Big U since he's been gone. And now these individuals, word is, are missing in action somewhere, hiding under their bunks in a fetal position with their thumbs in their mouths, shaking in a ball of terror. Because Big U may be on his way. Oh! Seti Nash, per normal, has all of the info.
Big U just got a win, and I don't know if the internet gonna like that one.
Uh-oh.
So here we go. Defendant Eugene Henley Jr.'s ex parte application to set briefing and hearing schedule for reassigned wiretap suppression motions. Declaration of Craig A. Harbaugh. Must be one of the Harbaugh, the coaches. I'm joking. This ain't no joking matter, though. Let's get to it. Introduction. Defendant Eugene Henley Jr. respectfully applies ex parte for an order setting a status conference on July 9, 2026, the first date both parties are available, and from that, conference setting a briefing and hearing schedule for the wiretap suppression motions reassigned to this court, docket numbers 174, 189, 194, 195, and 258. A status conference is the necessary first step. The recusal and reassignment have left both the schedule and the structure of the evidentiary hearing for this court to set. The July 15, 2026 hearing, the recused judge set will not go forward, and the July 3rd, 2026 supplemental briefing deadline was key to that hearing. The order that set them expressly permitted modification, docket number 342 at 2. A brief conference lets the court reset the schedule and define the hearing it will conduct in one step. Mr. Henley proposes that the court set the status conference for July 9, 2026, a supplemental briefing deadline of August 6, 2026, and a hearing on September 24, 2026, or October 8, 2026. Subject to the court's direction at the conference, the government takes no position on the briefing and hearing dates and defers to the court and does not believe a status conference is necessary. Wait, what you mean? You don't mean, wait, Jay, you talking about briefing on the old schedule before this court? Hold on. There is no longer any reason to hold the parties to the July 3rd, 2026 deadline. Briefing on the old schedule before this court has identified what it needs to decide these motions. Risk supplemental briefs that do not reach the court's concerns, and a further round the court would have to order. Setting a conference first lets the court define the briefing and the shape of the evidentiary hearing and the outset and receive one set of submissions built to answer its questions. So this ain't really about nothing. It's really about just setting it all up to have all the evidence you want to hear, the wiretaps and all that shit. And we'll get into that at the very end because there's something being said on the internet that I 1,000,000% disagree because of the phrase, if the shoe was on the other foot. But basically, we got to set this schedule up. We got to get all this shit straight before we even proceed. Let's make sure we got all this stuff set up. And the reason why is pretty interesting. On May 18, 2026, Judge Alain Rocha set a hearing schedule for all pretrial motions. Set the wiretap suppression motions for hearing on July 15, 2026, and set an evidentiary/Frank's hearing on Mr. Henley's motion to suppress intercepted communications for the same date, docket number 342 at 2. The order provided that the dates in this order may be modified as needed. Following the June 10, 2026 hearing, the court set July 3rd, 2026 as the deadline for any supplemental briefing on the wiretap motions in advance of the July 15, 2026 hearing, docket number 358. On June 22nd, 2026, Judge Rocha recused himself from the wiretap suppression motions. Wait, what? The court explained that because it had reviewed, considered, and authorized the pre-indictment wiretaps that are subject of the pending motions to suppress, it recused out of an abundance of caution, finding that a reasonable person with knowledge of all the facts would conclude that this court's impartiality might reasonably be questioned under 455A. The court denied Mr. Henley's pending request to reassign the motions. Nah, bro, you gotta let it happen. What the fuck is you talking about? Also, on June 22nd, 2026, the wiretap suppression motions and joinders, docket numbers, we ain't doing all that, were referred to a randomly drawn district judge and assigned to this court docket 359, docket 361, directing the clerk to reassign the motions to another district judge. On June 27, 2026, defense counsel proposed a schedule set out above to the government. Harbaugh declared on June 29, 2026, the government responded that it takes no position on the briefing and hearing dates and will defer to the court, and that it does not believe a status conference necessary. The government also advised that it is likely not available on July 2nd, 2026.
So in other words, they don't have it together whatsoever. The feds do not have it together. They do not have Big U as dead bang as people believe. It's a bunch of mumbo jumbo, and the feds are docking up the paperwork, being exposed. Big U is going to be on his way. If you have videos up on Big U disparaging him or something, now would be the time to take him down. I know some of y'all shaking in y'all fake ass Jordans.
But it's available on July 9th. So as we said before, and people went, the freaking comment section was split in half. We said the old judge had to go as far as the wiretaps go because he couldn't be unbiased. He approved the damn wiretaps. So you're not going to go back and then say, oh, I made a mistake. You're not going to do that. Nobody would reasonably say.
Well, for the most part, they're not going to correct their own wrongs. They're not going to do that. Once they, it's like a referee overturning his own call. Yeah, he said, damn it, I saw a foul. I called a foul. You challenge it, I'm going to still uphold the foul. Because I said that's what it was. Even though he may go look at the review and say, actually, it wasn't a foul. But many of them do not have the wherewithal to then say, well, it wasn't a foul. They're going to still stick with their same call. This is what the judge is going to do, more than likely. Also, if he approved the wiretaps, then there's set-in bias based on that alone. That pretty much eliminates the possibility that he will overturn his own authorization. He's the one that approved it, and now you're asking him to throw it out to say that the wiretaps will not be allowed for whatever reason. No, he's the one that said that they are going to be allowed and approved the wiretaps from the beginning. So he was going to have to get on. They was going to have to recuse him. He's going to have to recuse himself. They claimed they sent it to a random district judge. Nothing is hardly ever random in the system. Most of it is coerced, and they have machinations. This stuff is planned out, but they claim that it's a random judge that it has now went to, indicating an impartial judge, a fair judge, a judge who should be neutral, who has no stake in this, as opposed to the judge who just had to leave the case.
Hey, man, that judge was completely unbiased. So they're doing this shit by the book. Thank you, feds, for finally doing something right. Thank you, feds, for doing something right, because you can't look at the shit you did and then go, oh, I got this wrong, and think that if you don't point out something you got wrong, that we ain't gonna look at you and go, yeah, bruh, nah, hold the hell on. Nah, something ain't right. Go get somebody else, because you can't be the person to fix your own mistakes. That's why we have appeals and all of this shit. And judges getting booted off from hearing their own damn shit. So shout out to Big U's lawyers for catching that shit. We agreed, by the way, and that shit was split down the middle. People thought Big U was paying me, and I'm like, I'm just being fair as I possibly can. But let's continue on with this.
Thought Big U was paying him because he said that the judge was going to have to leave the case. Yeah, that's just really common sense. I can understand why the comment section may be split down the middle, because some people are going to say, of course, that the judge can be impartial. He could have made that ruling and still been neutral when reviewing the evidence and made another decision even if that decision overturned his previous one. If he's an ethical judge, this should be without hesitation. Something like that should be no problem. But again, a lot of these individuals do not have the wherewithal to overturn themselves, even when faced with the reality that they were wrong, with evidence, facts, brutal facts, that they were wrong about something. They still hold steadfast because they first put their stamp on it. It takes a lot of gumption to then turn around and overrule yourself. But some indeed have the wherewithal to do that. So that would be the argument, of course, that perhaps he should not have been taken off the case because he could have still made an impartial decision. I don't think so. I wouldn't have wanted him on my case. I'm just saying that perhaps would have been the argument.
Third part. Argument. A status conference on July 9, 2026 is the necessary first step. A status conference is the efficient way to reset these motions, and July 9, 2026 is the first date the parties can hold one. The court is entering the case after a year of litigation. Accordingly, it is important that the court has an opportunity to set its own schedule in the parameters of the evidentiary hearing it will conduct. A status conference lets the court do both at once. It also avoids the alternative supplemental briefs filed on the old schedule that may not reach what this court needs to resolve the motions, leaving the court to order a further round. The parties have conferred. The government advised that it likely could not proceed on July 2nd, 2026, but is available on July 9th, 2026. And July 9th is the first date both sides can appear. The conference should set the briefing schedule and the structure of the evidentiary hearing. The prior schedule did not contemplate argument alone. It set an evidentiary/Franks hearing on Mr. Henley's motion to suppress intercepted communications. A live evidentiary hearing turns on questions the court will want to settle. I said we'll want to. I can't read for shit right now. We'll want settled before briefing, which witnesses will be called, the order and time estimate for their testimony, and whether the parties should exchange witness declarations in advance to narrow the issues and shorten the testimony the court must hear. Defining these at a conference lets the court receive supplemental briefing and any supporting declarations built to its own procedure. Avoiding the need for further briefing, the existing dates do not stand in the way. The July 3rd, 2026 supplemental briefing date and July 15th, 2026 hearing were tied to a schedule set by the recused judge, and the scheduling order expressly contemplated modification. With the July 15 hearing gone, the July 3rd deadline serves no urgent purpose, and resetting both to dates the court selects is the orderly path. Ex parte relief is appropriate. Ex parte relief is the proper vehicle. On July 3rd and July 15, 2026 dates, the July 3rd and July 15, 2026 dates are imminent, and a regularly noticed motion cannot be heard before them. The need to reset arose through no party's fault from the recusal and random reassignment of these motions. Defense counsel conferred with the government, which takes no position on the relief requested. No party is prejudiced by setting a conference in a schedule the parties have already discussed. For the foregoing reasons, Mr. Henley respectfully requests that the court grant the application and set the proposed schedule, dated June 29, 2026. So what they're saying is basically, you're the new referee, judge. You set this shit. There is no rush to adhere to the old ruling, to the old schedule date. This is your shit. And the feds, they don't really give a shit, man. Like, they can say that, we're not available on July 2nd, but July 9th, we can. Man, we'll see. And there's a thing.
Either way, it's coming up rapidly. We at July 1st right now. Whether the date is July 3rd, July 9th, or July 15th, it is rapidly approaching. But okay, we have a new judge on the case with Big U. The other judge essentially had to recuse himself because of his prior involvement. So now that someone in the defense for Big U is apparently filing motions. So now that the new judge is in there, They're trying to apparently get more time and are going to try to influence this new judge, of course, who should not be biased. A random judge going to try to influence him with technicalities in the case to let Big U go, to drop the case entirely, guaranteed. That's where it's headed now. This is a big win for them, getting that judge off of the case. The judge who was clearly against him because he approved the wiretaps. He was not in Big U's corner. We can all say that. So getting him off the case has to be a big win for the defense and for Big U. I'm sure that this is what they all wanted, including Big U, wanted this individual off of the case, feeling like there's no chance for him to win with this individual residing as the judge. So, okay, there you have it. Let me know what you think in the comments. We'll see what happens, Big U. It's coming to a head soon, that's for sure. And he could indeed be on his way out. We'll see what happens. And if he is, then what? We'll see what, I've seen some individuals talking about this already. And their cheeks were shaking when they were talking about it. Some of these internet goofies, they worry. What if this man gets out this month? What am I going to do? I done sat here and popped it about it. Oh, man. The chickens always come home to roost. You got to be careful. We'll see. I'm sure Big U, he wouldn't get out on any nonsense. He's trying to get out and stay out. We'll see what happens, though. Let me know what you think in the comments. Shout out to Seti Nash. Stay safe and stay free, people.